Hello, this is Attorney Doug Jones. Welcome to Elder Law in 5 Minutes. Thanks for joining in today. Today we're going to be talking about the subject of this week's newsletter, which is when probate may be required and how to avoid it completely, which a lot of people would like to do. And by the way, if you don't get our newsletter, you can get it at no charge by going to elp.legal. You can just sign up and it'll be sent to your inbox every week. So today we're going to be talking about wills, trust, probate, and all of that good stuff. A revocable living trust is an overview here in general. Just helps people avoid probate. And a will, sometimes you have to, if you died, and you have to go through the supervised probate process after you die. So let me give you a quick example. Let's say mom and dad own their home, their car, bank account, checking, savings, brokerage account, maybe another little piece of property in their town. Then let's say dad dies first. Usually there won't be a probate when the first spouse dies unless they own separate property in their names. In that event, there may be a probate when the first one dies. But let's say mom and dad own everything jointly, so when dad dies, it all passes by operation of law to mom, no probate in that specific example. And let's say a few years later, mom dies, and mom has a will leaving everything to her kids. What do the kids do next? Let's say they want to sell me mom's home, and I want to buy it. So the kids and I make a deal for the house, and I've got a check. Can they give me the deed? Well, think about it a minute. Whose name is that deed in? It's probably in mom's name. So the day before mom died, mom could have sold me the house. She could have signed the deed. I could have given her a check. But now that she's passed away, the day after she dies, can the kids sell me that house? It's in mom's name. It's not in their name. So what do? They got a will, mom's will, that says she wants to leave it to the kids. She wants to leave it to the kids, but what do we have to do to make that happen? You have to probate that will. So the kids have to take it to probate court, go through the probate process, and ultimately get an order authorizing them to sell the house to me, and then we can do the transaction and I can purchase the house. So that's kind of a long process that a lot of people would like to avoid, and it can be avoided many times with a revocable living trust. So how does that work? Mom and dad set up the trust, they own it, dad dies, again, no probate because he and mom owned everything jointly. When mom dies, if she had everything titled to the trust, mom died, but her trust didn't die, and it holds title to her assets, and maybe her kids are the successor trustee, so the assets pass directly to the kids if that's what the trust says, and they get it immediately, and then they can sell the asset, the house, to me directly out of the trust immediately without the delay and cost associated with probate. I kind of equate it to cleaning your house, and this is kind of a crude example, but you'll get the point. So mom and dad have all of these assets. If they do a will, what they're doing is they're not cleaning up anything now. They're just signing a will saying what they want to happen later on, and they're letting the kids come along and sweep up the mess later. Sweeping up the mess would be moving the assets over to their names, and the way they do that is go through the probate process. On the other hand, if mom and dad had a trust, they're sweeping up their own mess, i.e. moving their own assets over to trust while they're living, and then when they die, they've already done all the work. All the kids have got to do is receive the assets and not go through the probate process, not have the delay and the cost associated with probate. So if you want to make things easier, I guess, for the kids, or you want to set it up where they receive assets immediately after you die, then in that example that we gave you in today, the trust would have been a better option. Sometimes, though, a will is a better option if there are maybe a lot of claims against the estate, or a lot of contentious issues, or money's owed to a lot of different people. A good thing about the probate process, it is a court proceeding, and it's a way for all of these issues to be resolved, a judge to hear all of these issues, render an order, and finally get closure. When you got the court order you got closure, then the assets can be distributed and life goes on. But for a lot of people, they don't have all of these issues. They don't, there's not a lot of claims, not a lot of debts owed to a bunch of different people, not a lot of contentious issues. So there's just no need for that. Probate in those situations is just overkill. Well, let's talk about cost just a minute. Yes, a trust costs more on the front end than a will because there's more to it. Remember, we're doing all of the work on the front end. But what about when you consider the back end? With a will, it costs less on the front end, but the kids are having to go through probate and do all of the work on the back end. When you factor in the probate cost, a lot of times the will is expensive, or even more so, sometimes much more so than it would have been had mom and dad just done the trust on the front end. Not to mention the hassle associated with probate. That's these intangibles like that you can't really put a price on. This is a difficult decision. If you haven't done your estate planning and you live in the state of Arkansas, we would be happy to visit with you. If you'd like to talk to us, just give us a call, 501-843-9014, or go to our website at arkelderlaw.com for more information. And if you haven't done so already, please subscribe to this YouTube channel and click the notification bell so you can be notified when we do future videos, so that you can be notified right away. If you like this video, please click that like button and share it with someone. And if you have comments about what you've done in situations like this, and in a probate situation, or how you've avoided it or not, please type the comments below. We love to receive your comments, and we appreciate you watching. Thanks for watching today. We'll see you again soon. Take care.